Hello friends, how are you? Today I am going to discuss an important judgment of Honourable Rajasthan High Court, which is pronounced on 13th Feb 2023, in which the accused has been acquitted from the charge of Prevention of Corruption Act. The judgment is quite important and a lesson for all of us, because after a fight of 38 years, the accused finally got a success. Just presume what type of pain he has occasioned and witnessed: the social troubling, the family troubling, the litigation troubling. But he was totally determined that he will fight and definitely he will win, and ultimately he has won the case. So this is an important criteria, an important lesson for all of us. So it is a matter of great consideration for all of us that while fighting the case for the anti-corruption, we have to be very much clever, we have to be very much strategic, and we have to know in which manner we have to enforce our right. So first I will discuss the entire case, and then I will give you some tips that if you are fighting an anti-corruption case, then what point you should burn in your mind so that you could easily contest the case in a motivated way. The judgment is passed, friends, by Honourable Rajasthan High Court. The SB criminal appeal number is 78/1985, the oldest appeal. The concerned parties were Hari Narayan versus State of Rajasthan. In this case, the appellant has challenged the impugned judgment of conviction passed by concerned learned Special Judge ACD, whereby the accused has been convicted under Section 161 of IPC and Section 5 subclause 1 subclause D of Prevention of Corruption Act 1947. And ultimately, in the light of Section 4 to 8 of CRPC, it is ordered that the sentences were ordered to run concurrently. The story of prosecution is that one of the person who is resident of Neemka Thana submitted a written report to the concerned DYSP ACD seeker, and his prime allegations are that he had purchased the tractor HMT in his father's name on 2nd of May 1979, and he wanted to change the registration of the tractor. He submitted the document before DTO, and DTO wrote an order and sent the same to the concerned clerk, that is Hari Narayan. It means the present appellant accused. When he went to Hari Narayan, he told him that there was no work with him to be done, the DTO would do. Then again he went to Mulchand DTO, but Mulchand said that Hari Narayan would do it. Then again he went to Hari Narayan, and appellant Hari Narayan told him that he will do the work, for the same he has to pay a sum of rupees 150. It means 50 for himself, 50 for Mr. Ashok Jain, and 50 for Mr. Mulchand, that is DTO. And ultimately, complainant shown his unwillingness, and ultimately he submitted a complaint by mentioning that he did not want to give the bribe amount, and inter alia he intended that the accused to be caught red-handed, and he filed a consent complaint before the concerned ACD, and the verification was done, the pre-trap was done, the post-trap was done, and ultimately the accused person has been trapped out in the proceeding. The accused appellant has been charge sheeted, and ultimately the charges were framed, and after hearing all the case, the concerned trial court convicted the accused under Section 161 of IPC and Section 5 subclause 1 subclause D of Prevention of Corruption Act 1947. Now it is replaced by Section 13(1)D of Prevention of Corruption Act 1988. The concerned appellant had denied the charges as I submitted earlier, and in the course of appeal, the primary arguments are that the learned trial court has committed a grave error while convicting the accused under Section 5 subclause 1 subclause D of Prevention of Corruption Act with Section 161 of IPC. His submissions are that the trial court has not read the prosecution evidence in the right perspective. His submissions are that the prosecution witnesses are highly interested and their evidences are unreliable. His submission is that the prosecution failed to prove the demand and acceptance, which are the primary key. And apart from that, the evidences of the complainant was also contradictory, and he has submitted that the concerned investigating officer wrongly investigated the case and left the Mulchand and Ashok Jain, because the bribe was demanded for these persons also, and they were left out from the proceedings. And it is submitted that the charges were wrongly framed, and apart from that, there is no iota evidence which could connect the concerned accused with the crime. So the primary attack of the defense is on the demand and acceptance theory, and in support and to buttress the contention, they relied on judgment of P. Satyanarayan Murthy and judgment of B. Jayaraj. in that cases it is held that the demand is sine qua non. So the basic thing, still we have to remember that even after coming into motion, the judgment of Neeraj Dutt, the Honorable Supreme Court is very much clear that the foundational facts are required to be proved, and apart from that, demand is required to be proved. And if demand, acceptance, and the other foundational facts are not established, the accused could not be prosecuted and convicted under the Prevention of Corruption Act. The concerned public prosecutor supported the impugned judgment and submitted that there is no force in the appeal, there is no merit in the appeal, and it is liable to be dismissed. The concerned court, while observing the case, has formulated the following observation. The key points are that as per the story of the prosecution, 150 rupees were given by accused to the concerned appellant, but the prosecution failed to prove the demand and acceptance of the bribe. Just there's a recovery of money, it could not be a ground that the accused is a culprit. The investigating officer deliberately left Ashok Jain and Mulchan, and apart from that, there are certain lacunas in the case, and the concerned prosecution totally failed to explain in which manner the amount has been demanded and it has been accepted, and that's why the concerned accused has wrongly been convicted by the concerned trial court. In that scenario, due to the facts and circumstances, the accused has been acquitted and the appeal has been allowed. So this is an important judgment as far as the rights of the accused are concerned who are facing the wrong cases under the Prevention of Corruption Act. So by this case, the primary key is that we have to focus on demand and acceptance. If demand and acceptance does not exist and the evidence are contradictory, and apart from that there is no supporting evidence, other evidences are interested, in that scenario the accused could not be convicted. So emphasis on this point, do the well cross-examination on this point as well before the concerned trial court. And apart from that, do not be disappointed, always be motivated, and just forget the adverse part of your case. Just presume that you are going to fight for a certain person. Not assume that you are fighting a case, assume that you are fighting a case for a certain person. And prepare the case, examine the whole file, and apart from that, you are required to read the file just for 10 to 20 times, and each and every time you will get a new point to fight before the concerned court. So emphasis on the case, no one is there to help you. You are only the person who could help yourself. So emphasize on your case, click out the point, just emphasize on the defense line also, and it is also requested not to change your defense line. Remember one thing, do not change your defense again and again. If you are going to do the same, in that scenario you are going to boost up the prosecution case, because section 20 of PC Act is there. If you are prosecuted under section 7 of the PC Act, section 20 of the PC Act will come into motion by your own fault. So just emphasis on this point, don't worry, and definitely we will win. So if this video enlightened you conceptually, just like and share it. For the updates, please subscribe my page. See you on the next topic. Till then, Jai Hind, Jai Bharat.